Uh, we are gathered here this afternoon to talk about the American presidency and the judicial system. Uh, During this lecture, we will talk about the mechanisms through which presidents affect the courts. And then subsequently, we will talk about the ways in which the courts affect the presidency. And as you can see, as you will see, both paths of influence are very potent. Presidents can strongly affect the judicial system. Conversely, the judicial system can have major effects on the conduct of a presidency. So let's share the screen with my computer. As you can see, the title is The Presidency and the Courts. We start with a discussion of the role of the courts relative to the presidency. And the courts are an institution that is designed for separation from politics. Their leadership involves multiple justices with tenure. There are norms against making decisions purely based on politics, and there's little control over the courts. There have been efforts in American history to impeach justices of the Supreme Court. I think earlier in a lecture I talked about the effort by Thomas Jefferson's administration to impeach Chief Justice John Marshall, which of course failed because of the explicit nature of the impeachment clause in the Constitution. So justices are designed to be there with tenure and independence. Historically, then, the role of the courts has been to represent the law, not the public. Ours is a nation of laws. You may have heard that term before. The courts were not designed to be policy-making institutions. They are designed to interpret the law and the Constitution. But by virtue of interpreting the law and the Constitution, courts indeed have become policy-making institutions. In the modern era, the courts have taken on a policy-making role. This is unavoidable due to the fact that interpreting what the law says necessarily implies policy-making. Presidents are sworn to uphold the law under the Take Care Clause of the Constitution. The courts are the ultimate arbiter of what the law is and says. This means that even the lowest court in the federal judicial system has power with respect to the presidency. The president can be ordered by even a district court to do things. For example, Nixon was ordered to turn over the Watergate tapes by a district court judge. He appealed the case all the way to the Supreme Court, but he ultimately had to comply with the district court judge's order. The presidency, in contrast to the Supreme Court, is a distinctly political office. It represents a segment of the public. The president must obey the law, as any other citizen does, but represents citizens, not the law. Because of these different types of representational roles, the president can sometimes find itself at odds with the court over matters of public policy. For example, Reagan and prayer in the public schools. Reagan wanted to pass a law that would facilitate prayer in the public schools. Unable to do that, violation of the First Amendment. The first Bush presidency, flag burning occurred on the courthouse steps in Tarrant County, Texas, during the first Bush presidency. Bush was outraged and wanted Congress to pass a law against flag burning. Congress did pass that law. The president signed the law. The Supreme Court struck it down because flag burning is protected behavior and it is protected under free speech. And so in order to ban flag burning, you would have to have a constitutional amendment. Other examples, Bush II and abortion. And finally, Obama and immigration. We recognize that Obama protected the Dreamers with DACA, and this was tested all the way to the Supreme Court and upheld by the Supreme Court. So presidents and the court may find themselves at odds over policy, or in the last case, Obama did not find himself at odds over policy. The relationship between the president and the courts is not one of agency, as in the president's relationship with the bureaucracy. And by design, the framers separated executive and judicial powers so that the judgment of one institution could not at will move policy. In fact, the Take Care Clause in the Constitution for the president means that there may be times when the president is constitutionally bound to enforce laws that the president disagrees with. Well-known examples, desegregation in Eisenhower. Eisenhower thought the 1896 case of Plessy versus Ferguson should have been upheld. And he didn't like Brown versus Board of Education and the thrust toward desegregating the public schools. Nevertheless, as chief executive, the Take Care Clause meant that he needed to comply, and he did comply. Another example is Richard Nixon and busing. The Supreme Court handed down various decisions on busing. Nixon disagreed with those decisions and indeed fought the Supreme Court on this issue and did what you might call drag your feet on busing. So he didn't comply with great fervor with the busing decisions by the Supreme Court. So in some respects then, the courts bind and constrain the presidency. The president's relationship with the courts tends to be, though not always, tends to be less visible than his relationship with Congress or with the bureaucracy. And yet, it is one of great importance. The courts are an agenda setter for the president and the political system. You can look at the work that I did with Roy Fleming and John Bodie, do a JSTOR search on our names, and you'll see that article on the court and agenda setting. The courts are an independent policymaker, separate from the president, Congress, and the bureaucracy. At times, a policy implementer. The court is at times a policy implementer. For example, the Supreme Court implemented a decision by District Court Judge William Wayne Justice. He ordered in the case Reeves versus Estelle in 1972 that the Texas prison system be reformed. Prisoners were being housed in tents at the Huntsville unit, and during cold weather, and it was deemed by the court as cruel and unusual punishment. And as a result, the Texas state legislature was required to pass legislation that would fund expansion of the housing facilities in the Texas prison system. And so William Wayne Justice ordered Texas to implement the policy that he had established in Ruiz versus Estelle. Some of you who are from East Texas may know who William Wayne Justice was. His father was a famous sheriff in Texas. Okay, so we're going to review over the next couple of slides the relationship between the president and the courts. And so I have here a slide that pictorially describes that relationship. You can see we have a constitution at the top, and then we have the Supreme Court below the Constitution. You can see that the Congress and the Senate determine the size of the Supreme Court. We noted earlier in the course that the size of the Supreme Court has varied from 6, actually 5, but then the sixth justice occurred before the decision on 5 could be made in effect. So it's varied in size from 6 to 11. And also, the Congress and the Senate approved the appointment of justices to the Supreme Court. And you see on the slide below the Supreme Court, we have Marbury versus Madison. The Constitution did not establish the Supreme Court as responsible for judicial review and as the sole interpreter of the Constitution. The Supreme Court took it upon itself to take on this role in the 1803 case of Marbury versus Madison. Marbury versus Madison gave the Supreme Court the power to review congressional acts at the bottom, presidential administrative actions, state laws, and lower court decisions. So this gives you the basic structure and the notion of the authority of the Supreme Court and where it comes from. Okay, moving to another slide here, we're going to look at the organization of the court system. The Supreme Court of the United States is at the top, and there are requests for reviews made to the Supreme Court. Through time, the Supreme Court has reviewed typically fewer than 100 cases. I guess there was a time earlier when it would review more than 100 cases, but in recent times it's been fewer than 100 cases. So there are requests for reviews. Where do those requests for reviews come from? They come from the federal court system, with the U.S. district courts at the bottom. Cases tried in the U.S. district courts can be appealed to the U.S. Court of Appeals. If a litigant is unhappy with what happens at the U.S. Court of Appeals, they can request a review by the Supreme Court of the United States. On the right-hand side of my flow chart, you will see the state court system. At the bottom, you see the state trial courts. The state appellate courts are above them, and then some states have Supreme Courts. And so the state system then moves from the trial courts to the state Supreme Court, and then you can have requests for reviews from the state side of the court system in the United States. Just an aside here before we move forward, the judges on the federal side of the court system, the left-hand side, are all appointed. They are nominated by the president and appointed after confirmation by the Congress and the Senate, the House and the Senate. The judges on the right-hand side of our flow chart here are typically, in many states, elected. In some states, fewer, I think, fewer states they are appointed, but typically they are elected officials. So this gives you the organization of the court system in the United States. Now here, what we have is the organization of the court system in a little bit more detail. Notice that the Supreme Court, created by Article 3 of the Constitution, consists currently of 9 justices appointed for life. And on the left-hand side of the graph, you have federal appeals to the Supreme Court. These are direct appeals from decisions holding state laws unconstitutional. So if the Justice Department holds a state law to be unconstitutional, that decision can be appealed directly to the Supreme Court. It is always a legitimate matter to appeal a finding of the federal system finding a state law unconstitutional. It's appealable to the Supreme Court. On the far right-hand side, you have the state, and there are, from the state systems, there are direct appeals from decisions holding the U.S. laws unconstitutional. In other words, a state court may actually find a U.S. law unconstitutional. If that happens, then it is directly appealed to the United States Supreme Court to settle that matter. In the center of our chart here, we have what are called certiorari, discretionary reviews. These are cases where the Supreme Court has a choice about whether to review a case or not. On the left-hand side with federal appeals, and on the right-hand side with direct appeals, those appeals are granted automatically to the U.S. Supreme Court. The certiorari, discretionary reviews, are appeals to the Supreme Court where the court has a choice about whether to review a case. So looking at the left-hand side of the certiorari review cases, you can see that we have the U.S. district courts. In the United States, there are 95 district courts. The district courts in the United States decide matters of law and fact, both with and without a jury. Sometimes as a bench trial, sometimes as a jury trial in the district courts. Note that below the U.S. federal courts, we have the federal agencies. In the last lecture, we talked about the administrative law courts, and we noted that the administrative law courts try cases in administrative law. We also noted that it is very rare for a case to be overturned in the federal court system. But on rare occasions, what you will see is that litigants associated with administrative law courts will appeal their case to the U.S. district courts. Those U.S. district courts will only overturn a ruling by an administrative law court unless there has been an error grounded in law and the Constitution. Note also that federal agencies can appeal directly to the U.S. Court of Appeals, so they have two paths for that. The 95 U.S. district courts then can, litigants can appeal cases on either side. The prosecutor or the accused can appeal cases to the U.S. Court of Appeals. There are 12 U.S. courts of appeal. These are called circuit courts. And note that they decide questions of law based on briefs and oral argument. In other words, the U.S. district courts decide issues of law and fact with and without a jury, whereas the courts of appeal don't have juries, and also they don't deal with the facts of cases. They deal only with questions of law, and they listen to oral arguments. Okay, once a matter has gone through the U.S. Circuit Court of Appeals process, if a litigant is still unhappy with the decision, then they can appeal it to the Supreme Court. The Supreme Court can grant certiorari review, but it is unusual for something coming out of the Court of Appeals to be granted certiorari review by the U.S. Supreme Court. On the right-hand side, we see the inferior trial courts and state trial courts. Those state trial courts, again, try questions of law, fact, and with and without a jury, just like the U.S. district courts do. There can be intermediate appellate courts. This exists in 20 states. And then finally, state supreme courts decide issues of law, again, based on briefs and oral arguments. Notice that this is kind of an analog, if you will, to the U.S. Circuit Courts of Appeals. And so that is a more full explanation of how the judicial system works in the United States. So presidents can influence the courts. They can both influence and be influenced by the courts. And so this first part of the lecture, we're going to talk about how presidents can influence the courts. Presidents can influence the courts through nominations and appointments, their solicitor generals, implementation, either vigorous or non-vigorous, by proposing legislation for judicial stripping. We'll describe what that is in a little while. And by making threats toward the courts. And so we will we'll talk about each of these things in sequence. The tradition of senatorial courtesy limits president's ability to influence district and appellate courts through nominations. In the past, senators, in fact, controlled appointments to the 95 district courts. There was a so-called blue slip process whereby senators could negate nominations from their home state. George W. Bush tried to alter this by not deferring as much to senators from the opposing party. Presidents have more control over appointments. By the way, you have a reading on the blue slip process that I encourage you to look at. Presidents have more control over appointments to the 13 appellate courts. There are 12 appellate courts that are geographically defined, while the 13th is the United States Court of Appeals, covering the entire U.S. Since multiple senators may be interested in the appellate courts, which cover multiple states. Even here, though, the tradition of courtesy to senators has some sway. The president has total control over nominations to the Supreme Court, except for the fact that he has to be able to get the nomination approved. Compromise is sometimes required in order to do that. Of course, presidents are constrained in their nominations to the court system by the partisan makeup of Congress. Consider, for example, the Merrick Garland nomination by President Obama in the 2016 presidential election year, where the Republican majority in the Senate decided simply that they weren't going to consider Merrick Garland's nomination because it was an election year. And so the nomination process sat idle for roughly 9 months until there was an election. Actually, until there was a new president. So Republicans controlling the Senate basically said they would not even consider the nomination until a new president was in office. Thoughts here? Was that stonewalling by the Republican majority consistent with the constitutional role of the Senate to provide advice and consent? Another factor that affects the president's ability to get nominations through concerns merit versus ideology. Senators tend to seek those who are compatible with their ideology. However, in practice, if someone is qualified for the job, it can be difficult to keep them from getting a judicial position. On the other hand, judgeships are often patronage plums handed out for campaign loyalty or partisan favors. For example, Clarence Thomas is on the Supreme Court because of his loyalty to the Reagan administration. He was the chair of the Equal Employment Opportunity Commission during the Reagan administration, and it was widely perceived that he was appointed to the DC Court of Appeals simply based on his service as the head of the EEOC during Reagan's time in office. District judges actually lobby for the position of district judge. It's a very good job, pays well, and it's tenured for life. Appellate judges are usually selected from among the district judges, though not always. The example that I just gave of Clarence Thomas. Clarence Thomas was appointed directly to the DC Court of Appeals. He was never a district judge. It is considered inappropriate for candidates to lobby for a position on the Supreme Court. Appointees to the judicial system are always attorneys. Mostly through history, they have been white males, though Carter and Clinton made some headway in making the courts more representative of the population. Bush nominated Hispanics and women to the federal bench. And of course, Obama was a person of color who increasingly nominated African Americans to the Supreme Court, as well as Hispanics and women. Republican nominees tend to be more conservative. Some would argue that they are also more strict constructionists. But on the other hand, what does the term strict constructionist mean? An argument can be made that, that nobody in this day and time is actually strict constructionist. Otherwise, there would be a very weak presidency. All Supreme Court justices were male Caucasians of European heritage until the appointment of Thurgood Marshall. Thurgood Marshall was the first African American appointed by Lyndon Johnson. Sandra Day O'Connor was the first female appointed by Ronald Reagan. Currently, the court has one African American, Clarence Thomas, one Hispanic, Sonia Sotomayor, three females, Ruth Bader Ginsburg, Elena Kagan, and Sonia Sotomayor, with the other five justices being old white men. These are John Roberts, Stephen Breyer, Neil Gorsuch, Brett Kavanaugh, and Samuel Alito. Interestingly, five current justices are Roman Catholic. These are Roberts, Kavanaugh, Alito, Thomas, and Sotomayor. Notice that there's a majority on the court of Roman Catholics on the Supreme Court. This is anomalous relative to the historical composition of the court. Three current justices are Jewish. These are Stephen Breyer, Elena Kagan, and Justice Ginsburg. Gorsuch was raised Catholic, but he attends an Episcopal church. Why so few Protestants on the current Supreme Court? It's a good question, and one that I don't have a ready answer to. Ginsburg is the oldest justice of the Supreme Court, having been born in 1933, and Gorsuch is the youngest, having been born in 1967. Eisenhower said that the biggest mistake of his administration was appointing Earl Warren. Since the Reagan administration, the judicial nomination process has become increasingly politicized. This is especially true for the appellate courts. Partisanship rather than qualifications have determined the outcome of the process. The process has become increasingly politicized during the second term of the Clinton administration, and it continues to be highly political all the way through Obama and Donald J. Trump. Party polarization seems to be dominating the process. There is a very informative Congressional Research Service study on judicial appointments that I have hot linked here. I encourage you to look at that study. Here's something drawn from that study. Note that this figure shows U.S. Circuit and District Court nominees and how long it takes from their initial nomination to confirmation. Notice the left-hand side is in days, and the right-hand side is in Congresses, and even below that, though, we have the presidents. These are Carter, Reagan, and so forth. The black line represents the U.S. Circuit Court nominees, and the green line represents the U.S. District Court nominees. You can see from this graph that during the Carter and Reagan administration, the duration, how long it took for a nominee to move from nomination to appointment had been increasing. And as I said a moment ago, you can see also from this graph that starting with Clinton, the duration of time between an initial nomination and approval increased quite sharply, especially for appellate court judges, but also for district court judges. That increase in duration, how much time it took to achieve appointment, continued to increase through George W. Bush. It remained very stable through the first 3 years of the Obama administration, but then during the first 6 years of the Obama administration, but then during the last 2 years of the Obama administration, that duration increased very, very sharply, obviously due to partisanship. And interestingly, the duration of the time for Trump nominees to both district courts and the appellate court to occur has declined, as shown by the graph. So the process has become more political, and evidence that it has become more political is in the length of time that it takes for nominees to get approved. Here's the data that that set of graphs is based on. And note also there's some additional information in this table. We have the median number of days for nomination to confirmation. So here's the last 2 years of Obama. The median number of days was 331 days, and he only got 2 nominations through. He only got 2 confirmed in that last 2 years. So this is strong evidence of the political partisanship during the latter part of the Obama administration. You can see also a pattern in the district court nominees. It took almost 300 days to get nominations through, and he only was able to achieve 18 nominations, whereas in the prior year, he had 109, and the subsequent year, during Donald J. Trump, there were 53. So partisanship played a big role during the latter part of the Obama administration. You can see various fluctuations in here associated with the number of nominations that get through. For example, you can see here during 95 and 96, when Republicans took over the Senate, that only 11 of Clinton's got through, and it took 167 days, which was a large increase from the 99 that had been taken, and so forth. So this gives you some raw data, part of which is the basis for the graph on the preceding slide. Okay, here's another take on this whole process, and you can see that some nominees took far more time than other nominees did. For example, here you can see during Clinton, there were 2 nominees for Clinton that took extraordinary amounts of time, 1,200 days for one, and 1,505 days for Richard Pace to be moving from nomination to approval. And you can see also some outliers here. The rest of it lies around this line. So most of the nominees for Clinton were approved in 90 days or around 90 days, and then some took more than a year, and then some took far more than a year. You see a similar pattern with George W. Bush, where it looks like there's 1, 2, 3, 4, 5 who took extraordinary amounts of time, and even several others that took a lot of time. Most of them, you can see down here the 90-day line. You can see most of them are scattered around the 90-day line, some around the 365-day line, and so forth. And so you can see during Obama, only 1 nominee took an extraordinary length of time, and that was Joe Pryor. And then finally, you can see during Trump, you see a lot of scatter around the 90-day line. So with Republicans in control of the Senate and Trump in the White House, the duration of time that it took for nominees to get appointed was significantly lower. Here's the same data for the district court nominees, and you can see a similar pattern emerging. We won't dwell on that one. U.S. Circuit Court and District Court nominees, the official ratings by the American Bar Association for nominees that were confirmed by the Senate. The ABA, the American Bar Association, rates the legal qualifications of those who have been nominated and confirmed by the Senate, and it rates those qualifications by well qualified, qualified, and not qualified. And you can see that well qualified nominees is in the far left column here for each president. So with Trump, 80% of his nominees were well qualified, 13.3% were simply qualified, and 6.7% were not qualified to be on the circuit court, the appellate courts. Notice this compares with prior presidents. No prior president before Trump had nominated somebody to the circuit court, the appellate court, who was not qualified to be on the appellate court. So Trump has a pattern here of nominating people to the appellate courts when they are simply not qualified to be on the appellate court. You see the same data for district court nominees. According to the ABA, the American Bar Association, 62.3% of Trump's nominees were well qualified, 34% were qualified, and district court nominees for Trump, 3.8% were not qualified at all. You can compare that to earlier presidents, and you can see the numbers are far less for earlier presidents, even non-existent for earlier presidents. Concerning the Supreme Court, there have been 119 nominees to the Supreme Court who have been confirmed and served. 44 of those were nominated, but they failed to be appointed for various reasons. This means that about 30% of all Supreme Court nominations failed. Court packing and nominations. In 1936, Roosevelt's New Deal had been struck down by the Supreme Court. Roosevelt was unhappy. Franklin Roosevelt was unhappy about this, and during the 1936 election campaign, he promised that he would pack the Supreme Court. That is, add members to the Supreme Court until he had a majority on the Supreme Court. The election was a landslide in 1936 for Roosevelt, partially based upon that threat to pack the Supreme Court. Congress did not approve Roosevelt's court packing plan. It is the Congress that has the authority to determine the size of the Supreme Court. The president proposed, and the Congress rejected the president's proposal to pack the Supreme Court. Nevertheless, the Supreme Court altered its position on the New Deal. The New Deal was validated through two important decisions in 1937. And so this is sometimes called the switch in time that saved nine. In other words, the switch in time that saved the the existing number of justices on the Supreme Court. There has been talk in the current election campaign of, again, threatening to pack the Supreme Court, and even some of the Democratic nominees suggested that if they had become the nomination, if they had received the nomination, that they would pursue the court packing issue. Nothing has come of it, and Joe Biden was not in favor of altering the number of justices on the Supreme Court. Supreme Court average liberalism. Here's a graph that I've extracted from one of my papers. What we have here is the average liberalism of Supreme Court justices as reported by the Supreme Court Liberalism Database. There is a database that contains every single decision the Supreme Court has ever handed down. And it's the data I'm using is from 1954 through 1990. What I want to illustrate here is how changing the specific justices on the Supreme Court can significantly alter the liberalism of the Supreme Court during the period between here and here. Here we have the pre-Warren Court, Earl Warren. Okay, the period here is the period of the Warren Court, and then Warren and several other justices retire, and so from here on out, what we have is initially the Rehnquist Court and currently the Roberts Court, although this data doesn't go up to the Roberts Court. Here's another take on the same thing. This is from a paper that I published in, I believe it was the American Journal of Political Science. And this is a bit fuzzy on the screen, but I think you can make it out. What I have here is the positions on the Supreme Court, the justices who occupy specific positions on the Supreme Court. The idea here is that when a justice changes in a position, you see liberalism changes. So here we have a change from one justice to another. Here's this justice, and notice the change to this justice didn't reap significant change. Here we have a justice who increasingly became more liberal through time, and then his replacement, and the position remains pretty stable in its liberalism. Here you see an extreme case where the move from one justice to the next two produces a large change in liberalism, and then movement to the next justice results in a justice who becomes increasingly liberal through time. So what can we learn from this? We can learn from this that when you change the composition of the Supreme Court by nominating and appointing a new justice, the liberalism of that position can suddenly change. Here we have a position 6 here. You have a case where that justice became increasingly liberal through time. And then with his replacement, you see a stabilization in the liberalism on the court. And so notice also, and I know this is a little difficult to read because it's fuzzy, we have positions 1, 2, 3, 4, 5, 6, 7, 9, and 10. Oops, sorry. 9 and 10. Why don't we have an 8 or an 11? The answer is because in the 19th century, there was a time when there were 11 justices, and specific positions were deleted. So with 11, we had the deletion of position 11. We also had the deletion of position 8. And so by tradition, these positions are numbered 1 through 7, and then 9 and 10. Just a tidbit of information. Okay, moving away from the president's ability to affect the Supreme Court through nominations and appointments, the president's Solicitor General affects the courts. Who is the Solicitor General? The Solicitor General is responsible for arguing cases before the appellate and Supreme Court. He or she decides what cases to appeal from district court decisions. Remember our flow chart a while ago. He may also ask for movement directly to the Supreme Court. The Solicitor General may also enter a case as amicus curiae, which is Latin for friend of the court. Political science research shows that the Solicitor General's participation also increases the probability of winning for the government. Also, when the Solicitor General enters a case as an amicus, then the likelihood of the court accepting the case increases. So the Solicitor General can have an effect on outcomes both by arguing before a court, and then also, rather than one of the lower attorneys arguing before the court, or also by entering a case as amicus on behalf of somebody somebody having a case in either a district or appellate court. Another way in which presidents can affect the Supreme Court is by proposing legislation or the threat of legislation that alters the court's authority. This is also called court stripping. The idea is that Congress has authority over the jurisdiction of the Supreme Court. It says what Supreme Courts can decide cases over. Now, court stripping does not pertain to matters involving the Constitution, but it does pertain to matters involving the law. For example, the Illegal Immigration Reform and Immigrant Responsibility Act of 1996, passed by Congress with the signature of Bill Clinton. It was intended to address the problem of illegal immigration. One section of that law was intended to clarify INS, the Immigration and Naturalization Service authority, with regard to grants of asylum. In that legislation, Congress stripped federal courts of jurisdiction over the INS decisions on whether and to whom to grant asylum. So effectively, the INS, rather than the courts, now decides whether to grant an individual asylum, and that decision can no longer be reviewed by a federal court. So here's one law that stripped the Supreme Court and the court system generally as of particular authority, the authority over who gets asylum. Another example of jurisdiction stripping is the Prison Litigation Reform Act of 1996. That legislation was intended to limit the litigation that prisoners could file regarding prison conditions and the civil rights of prisoners. The legislation restricts the remedies that a judge can provide in civil litigation relating to prison conditions. Yet another example of jurisdiction stripping is the Anti-Terrorism and Effective Death Penalty Act of 1996. This legislation was intended to reinforce the death penalty by making it more difficult for prisoners to delay execution through the courts. Accordingly, the law limits the number of habeas petitions filed by state prisoners in federal courts, in addition to other limits on federal court authority related to such petitions. Habeas petitions are requests that a prisoner makes asking a court to determine whether his constitutional rights are being deprived as a result of incarceration. Okay, yet another way that presidents can affect court decision, the courts themselves, is through differential enforcement of judicial decisions. There's a nice book by Greg Orfield, a former Harvard scholar. It was entitled Must We Bust? In the book, Orfield lays out how the Nixon administration did not implement the Supreme Court's busing decisions with great vigor. So in other words, the president can choose to enforce with vigor or with reluctance. And in this case, Orfield lays out the case that Nixon implemented the law with great reluctance. The chief executive is sometimes deeply involved in implementation of judicial interpretations, things like prison policy, civil rights policy, in all the areas where the chief executive is involved in implementing judicial policy. The president can do this with more or less vigor. Okay, there's a model in the judicial literature. Sometimes it's called the rational adaptation model. Sometimes it's called the rational threat model. And the argument in this theory is that courts respond to threats to their independence by adapting their decisions to avoid those threats. Sometimes a game theory approach is applied in applying this model. It's a bargaining game between the president, Congress, and the courts. Essentially, the result of the game is that courts respond to threats to their independence by changing their decisions in order to avoid getting those threats. Okay, so those are all the ways in which the presidency affects the courts. Now let's look at the flip side of this. The courts could also affect the presidency. And so presidents may not agree with court decisions, such as the Texas versus Johnson decision on flag burning and Bush 1 that I talked about a few minutes ago, or limits on prayer in the public schools, such have existed since the 1960s. Nevertheless, they are required to implement the law as interpreted by the courts. Presidents are charged to take care that the laws are faithfully executed, which means that the president has to follow the interpretations of the court. The courts also affect presidential authority with regard to administering the bureaucracy. Here's an example. There's a case decided in the 1930s. The title of the case was Humphreys Executor versus the United States. That case restricted the president's ability to remove appointed officials from independent commissions. President Hoover had appointed, and the Senate had confirmed, Humphrey as a commissioner of the FTC. But in 1933, Franklin Roosevelt asked for Humphrey's resignation since he was a conservative and had jurisdiction over many of Roosevelt's New Deal policies. Humphrey refused to resign. So Roosevelt fired him because of his policy positions. However, the Federal Trade Commission Act only allowed a president to remove a commissioner for inefficiency, neglect of duty, or malfeasance in office. Meanwhile, Humphrey died shortly after he had been fired. Nevertheless, his executor, the executor of his estate, sued to recover Humphrey's lost salary. A unanimous Supreme Court found that the FTC Act was unconstitutional and that Humphrey's dismissal on policy grounds was unjustified, and the court reasoned that the Constitution had never given illimitable power removable to the president. So currently the law is that the president cannot remove members of independent commissions based on Humphrey's executor. The president's authority as commander-in-chief has also been limited by the courts. A famous case, Youngstown Sheet and Tube Company versus Sawyer, invalidated Truman's seizure of the steel mills during the Korean War. In April of 1952, President Truman issued an executive order directing the Secretary of Commerce, Charles Sawyer, to seize and operate most of the nation's steel mills. This was done in order to avert the expected effects of the strike by the United Steelworkers of America. Did the president have the constitutional authority to seize and operate the steel mills? In a 6-3 decision, the court held that the president did not have the authority to issue such an order. The court found that there was no congressional statute that authorized the president to take possession of private property. The court also held that the president's military power as commander-in-chief of the armed forces did not extend to labor disputes. The court argued that the president's power to see that laws are faithfully executed refutes the idea that he is to be a lawmaker, quoting directly from the decision. Another example of courts limiting presidential power is the decision concerning whether military or civilian courts will hear a case. Note that this case is directly relevant to President Bush's actions with regard to terrorism. The case is titled Ex parte Milligan. It's a Civil War case. It restricted the right of the president to declare martial law and suspend habeas corpus, authorities presidents often assume during war times. A man named Lambton Milligan was sentenced to death by a military commission in Indiana during the Civil War. He had allegedly engaged in acts of disloyalty to the Union. Early in the Civil War, Milligan, a citizen of Indiana, had been a peace Democrat, one who believed that the South should be allowed to leave the Union in peace. Later, he became a major general in the Sons of Liberty, a group that planned to raid military prisons in the Midwest and release Confederate prisoners of war. In October 1864, before the raids could begin, federal troops arrested Milligan. He was tried by a military court-martial and sentenced to be hanged. Lincoln had suspended habeas corpus, which had enabled him to be tried by the military rather than by civil authorities. But Milligan's attorney applied to the nearest federal circuit court for the writ of habeas corpus. The case was certified to the Supreme Court. The question was whether the military court had the authority to try and convict a civilian when civilian courts were in operation. The court ruled that Lincoln exceeded his authority in suspending civil law. The holding was that martial law can never exist where the courts are open and in the proper and unobstructed exercise of the jurisdiction. Does a civil court have jurisdiction over a military tribunal? Justice Davis, speaking for the court, held that the trials of civilians by presidentially created military commissions are unconstitutional. Martial law cannot exist where civil courts are operating. Note that this applies directly to the prisoners who are held in Guantanamo with regard to the actions of the Bush administration. The courts have also affected the president's ability to maintain secrecy during wartime. In the case, New York Times versus U.S., this is the so-called Pentagon Papers case. This case pitted national security concerns versus First Amendment rights. In what came to be called the Pentagon Papers case, the Nixon administration attempted to prevent the New York Times and the Washington Post from publishing materials belonging to a classified Defense Department study regarding the history of United States activities in Vietnam. The president argued that prior restraint was necessary to protect national security. The case was decided together with United States versus Washington Post. So the question was, did the Nixon administration's effort to prevent the publication of what it termed classified information violate the First Amendment? And the answer was yes. In its per curiam opinion, that is, it was not a published opinion, the court held that the government did not overcome the heavy presumption against prior restraint of the press in this case. Justices Black and Douglas argued that the vague word security should not be used to abrogate the fundamental law embodied in the First Amendment. Justice Brennan reasoned that since publication would not cause an inevitable, direct, and immediate event imperiling the safety of American forces, prior restraint was unjustified. The courts have also limited the president's authority to implement a legislative agenda. In Carter versus Carter Coal Company, judged in 1936, and Schechter Poultry Corporation versus U.S. in 1937, the Supreme Court struck down Roosevelt's New Deal programs. Roosevelt then, as I noted earlier, threatened to pack the Supreme Court until he had a majority on the court. The court then altered its position in 1937 following the landslide election of 1936 in National Labor Relations Board versus Jones and Laughlin Steel Company, 1937, and U.S. versus Darby Lumber Company in 1941, and Wickard versus Filburn in 1942. The court overturned the earlier decisions and legitimated Roosevelt's New Deal. The courts have also prevented the president's powers of executive privilege. In United States versus Nixon, the president refused to surrender the Watergate tapes, claiming that they were privileged. The court restricted executive privilege, but first recognized it also. A grand jury had returned indictments against 7 of Richard Nixon's closest aides in the Watergate affair. The special prosecutor appointed by Nixon and the defendants sought audio tapes of conversations recorded by Nixon in the Oval Office. Nixon asserted that he was immune from the subpoena, claiming executive privilege, which is the right to withhold information from other government branches to preserve confidential communications within the executive branch or to secure the national interest. It was decided together with Nixon versus the United States. So the question before the court was, is the president's right to safeguard certain information using his power of executive privilege entirely immune from judicial review? The court said no. The court held that neither the doctrine of separation of powers nor the generalized need for confidentiality of high-level communications without more can sustain an absolute unqualified presidential privilege. The court granted that there was a limited executive privilege in areas of military or diplomatic affairs, but gave preference to the fundamental demands of due process of law and the fair administration of justice. So the president must obey a subpoena and produce the tapes and documents. Nixon resigned shortly after the release of the Watergate tapes. In Nixon versus Fitzgerald in 1984, it involved the case where in 1968, Fitzgerald had then been a civilian analyst for the United States Air Force. He testified before a congressional committee about inefficiencies and cost overruns in the production of the C-5A transport plane, which at the time was the largest transport plane in the world. Roughly a year later, he was fired. This was an action for which Nixon took responsibility. Fitzgerald then sued Nixon for damages after the Civil Service Commission concluded that his dismissal was unjust. So was the president immune from prosecution in a civil suit? The answer was yes. The court held that the president is entitled to absolute immunity from damages liability predicated on his official acts. Note, on his official acts. This sweeping immunity, argued Justice Powell, was a function of the president's unique office, rooted in the constitutional tradition of separation of powers and supported by our history. However, with changes in the court decided in the opposite direction in Clinton versus Jones. Clinton versus Jones decided in 1997, presidential immunity from lawsuits while in office resulted from their official acts arose during Nixon. Under the doctrine established in U.S. versus Nixon, they are immune. Presidential immunity from lawsuits more generally while in office. Paula Jones filed a suit out of Fairfax, Virginia that was financed by the Christian Coalition. She sued Bill Clinton. She alleged that while she was an Arkansas state employee, she suffered several abhorrent sexual advances from then Arkansas Governor Clinton. She claimed that her continued rejection of Clinton's advances ultimately resulted in punishment by her state supervisors. Following a district court's grant of Clinton's request that all matters relating to the suit be suspended pending a ruling on his prior request to have the suit dismissed on grounds of presidential immunity, Clinton sought to invoke his immunity to completely dismiss the Jones suit against him. So while the district judge denied Clinton's immunity request, the judge ordered the stay of any trial in the matter until the end of Clinton's presidency. On appeal, the Eighth Circuit Court affirmed the dismissal denial, but reversed the trial deferment ruling since it would be a functional equivalent to an unlawful grant of temporary presidential immunity. So the question before the court was, is a serving president, for separation of powers reasons, entitled to absolute immunity from civil litigation arising out of events which transpired prior to his taking office? The answer decided by the court was no. In a unanimous decision, the court held that the Constitution does not grant a sitting president immunity from civil litigation except under highly unusual circumstances. After noting the great respect and dignity owed to the executive office the court held that neither separation of powers nor the need for confidentiality of high-level information can justify an unqualified presidential immunity from judicial process. While the independence of our government's branches must be protected under the doctrine of separation of powers, the Constitution does not prohibit these branches from exercising any control over one another. This, the court added, is true despite the procedural burdens which Article 3 jurisdiction may impose on the time, attention, and resources of the chief executive. So the decision here means that presidents can be sued while they are in office. The difference between this case and the earlier Nixon case is that Nixon was being sued in matters pertaining to his powers exercised as chief executive. Clinton was being sued on matters that were associated with what happened before he assumed office. And so presidents are not entitled to an unqualified immunity. The courts have also affected the president's ability to implement policy. In Clinton versus City of New York, the court dealt with the president's ability to implement the line item veto that had been approved by Congress. We talked about this in an earlier lecture, the legislative section. This case consolidated two separate challenges to the constitutionality of two cancellations, two vetoes made by President William J. Clinton under the Line Item Veto Act. In the first, the City of New York, two hospital associations, a hospital and two healthcare unions, challenged the president's cancellation of a provision in the Balanced Budget Act of 1997, which relinquished the federal government's ability to recoup nearly $2.6 billion in taxes levied against Medicaid providers by the state of New York. In the second case, the Snake River Farmers Cooperative and one of its individual members challenged the president's cancellation of a provision of the Taxpayer Relief Act of 1997. The provision permitted some food refiners and processors to defer recognition of their capital gains in exchange for selling their stock to eligible farmers cooperatives. After a district court held the act unconstitutional, the Supreme Court granted a certiorari on expedited appeal. So the question before the court was, did the president's ability to selectively cancel individual portions of bills under the Line Item Veto Act of 1996 violate the presentment clause of Article 1 of the Constitution? The court held in a 6-3 decision that it did. So the answer was yes, it violated Article 1 presentment clause. The court explained that under the presentment clause, legislation that passes both houses of Congress must be either entirely approved or rejected by the president. The court held that by canceling only selected portions of bills at issue under authority granted to him by the act, the president in effect amended the laws before him. Such discretion, the court concluded, violated the finely wrought legislative procedures of Article 1 as envisioned by the framers. Okay, finally, let's talk a little bit here about Donald J. Trump and the court. The courts have limited time and time again what Trump said he would do during the 2016 election campaign. For example, he issued several travel bans. They were struck down on the basis of due process, rulemaking decisions. The court, Donald J. Trump had attempted to negate rules simply by issuing executive orders or presidential memoranda. And the court ruled that the president doesn't have the authority to negate rules. The president has to use the same rulemaking process that was used to put the rule in place in the first place. Due process has been applied by the courts generally as it pertained to presidential actions during the Trump administration. More generally, it has been clear from the start, just from very early in the Trump administrations, that the courts can be a considerable impediment to presidential action when those presidential actions are inconsistent with existing law or the Constitution. And so presidents are highly constrained by the courts. That was a lesson learned very early by the Trump administration. Okay, so we'll stop sharing the screen now and conclude this lesson. This has been a rather lengthy lecture concerning the Supreme Court and the appellate and district courts and the president's ability to affect those courts. So we've talked at length over the ways in which presidents can affect the courts. We've also talked about the ways in which the Supreme Court and the lower courts can actually affect the presidency and presidential actions. They are not only an impediment to presidential action, they can strike down various presidential actions. And as a result, the president must always be mindful of whether or not the decisions made are consistent with the laws and the Constitution. Because if they are not, those decisions will inevitably be addressed by the court, and the presidential actions will quickly be amended by the Supreme Court, if not negated by the Supreme Court. So we have reached the end of the last lecture for this semester. We look forward in coming periods to a quiz, and subsequently to that, to a final exam. I wish you all great health and safety, because that's the most important thing. But I also wish you success in the coming weeks as you are quizzed and take your final exam. With that, I will bid you a fond farewell.